Ladies and gentlemen, your honors, good evening. Status quo confronts Philippines with many unhappy, troubled, and failed marriages. Couples in such marriages are imprisoned and deprived of the quality of life they deserve due to lack of remedy in our present law. Although we have legal separation, declaration of nullity of marriage, and annulment, these remedies do not directly answer the problem of a marriage which was seemingly good at the start, but gone chaotic during the marriage. The problem with the present law is that legal separation only perpetuates a dead marriage, a marriage only in paper, and that the grounds for annulment and declaration of nullity require a juridical antecedent which is unlikely found. These problems will be answered by the legalization of divorce. This side of the House proposed the legalization of divorce based on the following grounds. First, commission of grave violence against the spouse or their children. Grave characterized by habituality and serious physical violence. And second is that psychological incapacity without the need of proving the juridical antecedent, as it may manifest only during the marriage, thus effectively repealing Article 36 of the Family Code. The following shall be the safeguards of the law. State intervention in the form of mandatory pre- and post-divorce counseling for a period of 1 year before and after the case is filed, and protection of battered spouse. Second is that legal support by working spouse to the other spouse during the proceeding in case the other spouse has no... Yes, Your Honor.
Madam Speaker, can you discuss how the state intervened the marriage?
Your Honor, the state will intervene in said marriage in a way that the state will still protect the said marriage by having the said mandatory pre and post reconciliation in order to protect the negative effects of the said divorce. Your Honor, may I continue? And that third, divorce obtained by Filipinos abroad may be recognized if it conforms with our law. The following shall be the effects. Status of children is legitimate and given to... Yes, Your Honor.
Do you limit the parameters of your proposition to 3 grounds: serious physical violence, psychological incapacity, and the one under Article 26 of the Family Code?
Yes, Your Honor. May I continue, Your Honor? And that custody of children belong to the innocent spouse, parties can validly remarry, marriage deemed existed but ceased to exist, and that settlement of property regime in accordance with law. Now going to my argument. Divorce is not anti-family nor unconstitutional, unlike what opponents contend. The definition of a family should not be strictly limited to that of a nuclear family. In our context, solo parents and extended families are recognized. The word family should be based rather on the real and actual relationship between the parties. In nullity and declaration of marriage, a child suddenly disowned by history and past relationships. Why? Because their parents are deemed not married. In our paradigm, we will only sever the contractual relationship and the biological and emotional ties remain, which is what the constitutional protects. And also, divorce is necessary and real in those abusive marital relationships. Yes, they file for legal separation, but they desist because of fear of not economically supported, or they condone their husband because of the violence they undergo. And then, the baiting continues. With divorce, their necks are freed from the hands of their evil spouse. And then, an empowered and independent individual emerges, which can build a new and quality life with her children. Thank you.
All right, JP, 2 minutes to interpolate Gwen.
Just a clarificatory question. Are the grounds that you said your own, or are these the grounds provided by the current pending bill about
It
divorce?
is our own.
Alright, so are you aware of the current bill, the pending bill of divorce?
The 1779.
Yes.
Yes, Mr.
So are you also aware that there are also added grounds there, such as irreconcilable differences, wherein it can also be a ground for divorce?
It's not our concern, Mr. Speaker, because we have limited the said grounds in this.
Yes or no, please?
No.
So you portray divorce as a tool of the woman against the abusive spouse, right?
Yes.
But women are not the only party who can file divorce, right?
Yes, that's why we said
Alright, yes or
spouse
no,
and
please?
not only
Yes or no,
women.
please? Therefore, the male spouse who is abusive can also use the same mechanism to forward the patriarchal interests and to abuse the woman, right? Yes or no?
It's spouse. We said spouse and
Yes
not
or
only
no, please?
women.
Yes,
spouse.
precisely. So therefore, the man can also use the same mechanism that we're providing to abuse the woman, right? Yes or no?
No.
Is divorce primarily to protect the women's right?
The spouse, because it's not only the women who are abused.
Alright,
Mr.
so
Speaker.
thank you for admitting that. But are you aware of the present existing mechanisms such as the Anti-Violence Against Women and Their Children's Act?
Yes.
Are you aware that under the same law, it already provides for the remedies that you want in this debate?
Yes, but in our
Yes or no,
proposition-
please?
Yes.
Alright, thank you. So you can see that the status quo is already providing mechanisms to address the problems.
But it is insufficient.
Yes or no,
It is
please?
insufficient, Mr.
Yes,
Speaker.
yes
it
or
is
no, please?
insufficient. No.
Do you agree that how the bond can also be dissolved in annulment or via annulment through psychological incapacity?
Yes.
So you are also admitting that there is really no uniqueness in the bill that you are proposing because at the end of the day, the spouse can also resort to what the present law provides,
No,
right?
Mr. Speaker.
All right.
2 minutes now to rebut Gwen and advance your argument.